This is part 26 of my journey through the court system in the state of Connecticut over the last 10 years. So in part 25, we left off where we were just going to be starting the April 8th, 2022 hearing, which took place at the New Haven Superior Court between me and Matt. So on April 8th, 2022, we had a hearing in front of Jane Cupson Grossman, and this was the first time that we ever appeared together in front of Jane Grossman. This hearing was regarding an emergency ex parte custody application that I had filed. And if you haven't seen the hearing, I played it in an earlier one of these videos. It's also on YouTube. You could watch it, but during this hearing, Jane Grossman was extremely biased. She acted outside the bounds of her judicial authority during this hearing, and you can go back and listen to it. And this was the very, very first time that she ever met us. So the April 8th, 2022 hearing reveals a calculated continuation of Matt Lodice's perjurious pattern established in previous proceedings, demonstrating his systematic strategy to manipulate the court through his false testimony designed to support his custody objectives while concealing his criminal conduct. Lodice perpetuated his false abandonment claims by testifying that exchanges had consistently occurred at Cumberland Farms in Naugatuck, Connecticut, contradicting the established reality that both parties had mutually agreed to use my mother's home in Woodbridge for exchanges since September of 2021. The transcript reveals Lodice's admission that the meeting place we have now is 20 minutes from her house and 30 minutes from mine, attempting to justify the Naugatuck location despite his own knowledge that they had not used this location for several months. This testimony directly contradicts his March 9th, 2022 statements in court to Magistrate Jennifer Aguilar, where he claimed that I had abandoned Angelina by failing to appear at exchanges. So this systematic nature of deception demonstrates willful perjury under Connecticut General Statutes Section 53A-156, as Lodice deliberately provided false testimony material to the proceedings to support his custody strategy while concealing his own pattern of coercive control and custodial interference. During the hearing, he committed clear perjury regarding his residence, testifying under oath that he had moved to New Britain last month when confronted with evidence that police had verified his continuous residence at 23 Lyman Street since January 1st, 2022. This false testimony represents a calculated attempt to conceal his systematic use of his mother's Waterbury address to frustrate service of process and manipulate venue requirements. Connecticut General Statutes Section 46B-4 requires accurate residence information for proper venue determination, and Lodice's false testimony violates both perjury statutes and procedural requirements governing family court jurisdiction. The materiality of this false statement becomes evident when considering that proper residence information is essential for custody determinations, support calculations, and enforcement proceedings. Most significantly, Lodice failed to challenge or deny my sworn testimony that he had not paid a single dollar of his court-ordered child support since November 20th, 2021, and had not paid a single dollar toward court-ordered child care payments since January 15th, 2022. This strategic silence, combined with his subsequent attention when Judge Grossman suggested that obtaining custody would eliminate contempt liability, reveals his calculated strategy to evade support obligations through custody manipulation. His documented income from Whole House Remodeling Company, LLC, and cryptocurrency trading profits of over $40,000 demonstrate his ability to pay support, making his non-payment willful contempt designed to coerce me into accepting unfavorable custody agreements. Lodice's testimony that my mother told him that she wasn't going to be taking her anymore from him represents additional perjury designed to obstruct the practical exchange solution that both parties had used successfully for months. His claim to have proof and text messages was never substantiated with actual evidence, and this testimony directly contradicts the established pattern of successful exchanges at the grandmother's home documented throughout the proceedings. This false testimony was material because it designed to prevent the court from ordering the practical exchange solution that would eliminate Lodice's ability to manufacture more abandonment claims. Judge Grossman's conduct throughout this hearing violated both procedural and substantive due process requirements under the 14th Amendment. Her repeated interruptions of me, saying things like, "Put that away," "Stop talking, young lady," while allowing Lodice uninterrupted narrative testimony, violated the fundamental due process requirement of meaningful opportunity to be heard, established in Armstrong versus Manzo, which is a United States Supreme case from 1965. Matthews versus Eldridge, another Supreme Court case from 1976, requires courts to consider the private interests at stake, the risk of erroneous deprivation, and governmental interests when fundamental rights are affected. My fundamental parental rights deserve heightened protection, yet Grossman's proceeding maximized the risk of erroneous deprivation while denying adequate procedural protections. Connecticut Practice Book Section 25-50 explicitly requires courts to state the factual basis of its decision on the record when ruling on emergency motions, yet Judge Grossman provided no factual findings supporting her denial of the emergency petition. Her conclusory statement that there is no emergency lacks any legal or factual foundation and violates both state procedural requirements and federal constitutional standards. In re Galt, another U.S. Supreme Court case from 1967, it was established that due process requires courts to provide reasoned explanations for decisions affecting fundamental rights, and Grossman's failure to articulate any basis for her ruling violates this constitutional mandate. Judge Grossman's statement to Lodice that if you're the custodial party, I don't want to hold you in contempt for not paying your child support represents egregious judicial misconduct that violates multiple provisions of the Connecticut Code of Judicial Conduct. Canon 2.2 requires judges to perform all duties of judicial office fairly and impartially. Yet this statement provided Lodice with specific legal advice about how to evade his support obligations through custody manipulation. Canon 2.11 requires disqualification when the judge's impartiality might reasonably be questioned, and Grossman's coaching of one party while silencing the other creates an irrefutable appearance of bias. This conduct also violates Canon 2.9a, prohibiting ex parte communications and judicial advice that gives one party an unfair advantage. The transcript reveals systematic gender-based discrimination through Judge Grossman's disparate treatment of the parties. She addressed Lodice respectfully while referring to me as young lady, a diminutive form that judicial conduct literature recognizes as evidence of gender bias. Her threat to kick people out of my courtroom for interrupting was directed solely at me, despite Lodice's own interruptions, demonstrating discriminatory enforcement of courtroom decorum. This pattern violated equal protection principles under the 14th Amendment of the United States Constitution and the Connecticut Code of Judicial Conduct, Rule 2.3, prohibiting bias and harassment based on gender. Judge Grossman's refusal to consider evidence of Lodice's coercive threats, including either you meet me at this gas station per the agreement or I'm going to say that you abandoned Angelina, violates Connecticut Public Act 21-78, also known as Jennifer's Law, which specifically defines coercive control as domestic violence requiring judicial intervention. Her dismissal of this evidence as a mere scheduling dispute ignores the statutory mandate to protect victims of domestic violence and represents a fundamental misapplication of Connecticut law. Green versus McElroy, a United States Supreme Court case from 1959, requires courts to consider all relevant evidence when fundamental rights are at stake, yet Grossman systematically excluded evidence of abuse while accepting Lodice's unsubstantiated claims. Systematic disparate treatment documented throughout the hearing violates equal protection principles by providing fundamentally different procedural protections based on gender and party status rather than legal merit. Follow for part 27 to hear all the other reasons why the 4/8/22 hearing was a complete violation of my rights.